Yes. Good evening, everybody. I, Dr. Meenakshi Kalra, welcome you all on behalf of the Supreme Court Advocate on Record Association to this lecture series. Today, we've all gathered here for one of the important exam of leading cases in the upcoming AOR examination, wherein our esteemed speaker will enlighten us on Article 226 of Constitution of India, discussing independence of judiciary and appointment of judges. We have the honor to have with us today Senior Advocate P.B. Suresh, sir. We welcome you, sir, and we are thankful to you for taking out time and discussing the 6 cases, discussing Chandan Kumar versus Union of India, Roger Matthews versus South Indian Bank, Madras Bar Association versus Union of India, Supreme Court Advocate on Record Association versus Union of India, Dheeraj Moore versus Honorable High Court of Delhi, Kavita Kamboj versus High Court of Punjab and Haryana. We're showcasing this lecture live on YouTube, and if anybody has any questions, the same may be put in the chat box and the same will be taken up in the end by Sir. I'll just start with a brief introduction about Sir. Sir is a senior advocate practicing in the Supreme Court of India. He was designated as a senior advocate by the Supreme Court of India in 2024. He graduated in law with a gold medal and has an extensive experience of over 3 decades in litigation, having appeared in the important cases in various fields of law like constitutional law, commercial law, corporate laws, including admiralty law and maritime law. He has also been an amicus in a lot of various important matters and dealt with a lot of landmark cases like the Puttuswamy judgment and also in the religious freedom cases. He's appeared in many important and sensitive constitutional and political matters as well. He's participated in various seminars and conferences at the national level and presented papers on various legal issues of topical importance. I request you, sir, to please start with your lecture now.
Yeah, thanks a lot. Thanks for the nice words. Very generous of you. Good evening, everyone. And despite it being a vacation, it's heartening to see a lot of you hitting on your books because of the examination. Anyway, it's one more week before you start having your vacations once the exams are over. And coming to the point for which we have assembled today, there is the topic that's been given to me to address, and let's have it as an interactive session. One is on independence of judiciary, and the second topic is on appointment of judges. See, both these topics are that way directly interconnected for the simple reason that appointment of judges and independence of judiciary is a quid pro quo, in the sense that without one, if the appointment of judges is not a fair procedure, a transparent procedure, then the very efficacy of the system is not transparent, and there would be lots of doubt on the very integrity of the system itself. So therefore, the first and foremost important point regarding appointment of judges is that how are judges appointed? Number one, because ultimately, if the judges are appointed and they are fair people, then the confidence of the people and the confidence of the litigants also, in a way, enhances the system's role in acting as shock absorbers in the society. Coming directly to the point, see, if you look at the Constitution, I would like you to refer to 4 important provisions regarding appointment of judges. The first provision is Article 124, and the second provision, the Article 124 deals with union judiciary, and it also describes and it also postulates the way the judges will be appointed in this country. The second thing is the second article of importance would be Article 217, which deals with appointments and conditions of office of a judge of the High Court. It deals with the appointment of High Court judges, their transfers, as well as their method of removal in case such a situation arises. Hopefully, it should not arise, but in case such a situation arises, then 217 takes care of that, as well as Article 124, that too takes care of the same in respect of appointment of judges of the Supreme Court. The third article is about Article 233. This is with regard to appointment of district judges. Now, when we talk of appointment of judges, it does not confine, let's not confine ourselves to the appointment of High Court judges and the Supreme Court judges only, because the judiciary has a whole and maximum number of litigation. The starting part of litigation is at the subordinate court level and at the district court level. And that being the case, let's have a brief discussion on Article 233 regarding the appointment of judges at the level of district judges as well as the subordinate courts thereafter. And then the most and the foremost important, one of the important issues that arise today is the appointment of the members and chairman and vice chairman of tribunals, administrative tribunals, and other tribunals which have been created under some special enactments. That is constituted under Article 323A and 323B of the Constitution. So, if you look at the case laws that we have today, namely Chandrakumar versus Union of India, Roger Matthew, and the Madras Bar Association, deals with, as well as the fourth one regarding Supreme Court Advocates on Record Association, Dheeraj Moore, as well as Kamita Kamboj. It's a very good collection of cases which covers the entire gamut of subject. Full marks to SCAORA for having selected the case laws on a point which covers almost entirely the subject at hand that we have today. If you look at this, as far as this one is concerned, let's have a look at Article 124 straight away. Now, coming to Article 124, it contemplates that every judge of the Supreme Court shall be appointed by a president by warrant under his head, under his hand and seal after consultation with such of the judges of the Supreme Court and of the High Courts in the states as the president may deem necessary for the purpose, and shall hold office until he attains the age of 65 years. Now, let us keep this slightly, the wordings aside, and let us look at the scheme of things that we have constitutionally and structurally engineered today. Today, for the appointment of Supreme Court judges, we have a system called as a collegium system. Under this collegium system, the names also emanate from the judiciary itself. And there is a collegium of 5 Supreme Court judges, including the Chief Justice, and 4 other senior most judges of the Supreme Court. These 5 judges recommend names, and normally the names have to be unanimous to be binding on the president. Now, once these names are recommended, it goes to the president, and the president has to act on the advice and aid of the cabinet. So effectively, although the president signs the warrant, the decision is taken by the government, namely the cabinet, because it is the cabinet which advises the president as to how to go about with the names that has been suggested by the Supreme Court. Now, once the names go from the Supreme Court collegium to the president, then the advisory process starts. The president has got 2 choices. The president can, if it is a unanimous decision, in the first instance, the president, he or she, as the case may be, would be bound by the decision of the collegium. That's the first point. The second point is, in case the president considers it necessary that it has some doubts on regarding a particular judge or particular appointment that is being suggested, then it has got one option, namely to send it back for reconsideration. Now, once it is sent back to reconsideration and it is again reconsidered by the collegium and sent back to the president, then the president is bound. Therefore, ultimately, today the position structurally that we have for a High Court and a Supreme Court judge to be appointed is that the president is bound by the name suggested by the collegium. The only aspect is to be a gray area, probably could be what in case the decision is not unanimous by the Supreme Court collegium. Then as we can go through the case law, once we go through the case law, we'll find out that then it would not bind the president if it is not unanimous. Therefore, you generally have appointments which are suggested with the names that are suggested are unanimous with absolutely no any differences of opinion among the collegium judges, because there could be a problem of it returning back to the collegium. So therefore, once the decision is anonymous, then it binds the president. Now assume for a moment it is not unanimous. Then what happens? Then it does not bind the president, but it can definitely, the president can refer it back to the collegium. And once the collegium again reiterates by way of a fractured mandate or a fractured consent, then the president is not bound. So this is the only area where the president is not bound by the suggestion given by the collegium. That is where it's a fractured advice given by the collegium in which all the 5 judges do not agree, in which case the president is not bound. And even if it is sent second time, but if in the second instance, if it is sent by unanimously by all the 5 judges, the president is bound. But in case it is again fractured, then he is not bound. So the circumstances today that we have structurally for the appointment of High Court and the Supreme Court judges under Article 124 and 217 is that the primacy or the primacy of opinion of the Supreme Court College has to be accepted today. There is no way that the government probably can suggest, that's what the third reference case talks about, the third judge's case talks about, is that probably the government can suggest a name which the collegium can consider. But ultimately, the primacy of opinion lies with the Supreme Court Collegium. That is with regard to appointment of judges of the High Court and Supreme Court. The second, now let us straight away get into the first case in hand, which has been given for a discussion today. Now, as far as the third one is regarding the subordinate judiciary, which I said regarding Article 233, and the last one is regarding Constitution of Administrative Tribunals. The first case which has been given to us is on L. Chandrakumar versus Union of India, namely 1995 1 SCC 400. See, this is a landmark judgment as far as the constitution of the tribunals is concerned, as well as the primacy and the basic structure theory doctrine is concerned. Now, what Chandrakumar's case arose like this, that it tested the constitutional validity of Articles 323A and 323B of the Indian Constitution, which was inserted by way of a 42nd Constitution Amendment Act 1976 with effect from 3/1/1977. 323A and 323B contemplated the establishment of administrative tribunals. That is, 323A contemplated the establishment of a central administrative tribunal for the purpose of looking into service conditions wherever there is a dispute with regard to service conditions, namely service jurisprudence. An administrative tribunal was constituted. 323B contemplated the constitution of other tribunals under different enactments. For example, you can straight away think about the constitution of the National Consumer Commission, or there are so many tribunals, each constituted under a special enactment or a special act of parliament. Now, therefore, 323B gave the power to the central government, the power to the legislature for the constitution of tribunals. Now, the need arose for the constitution of tribunals because the high courts were already overburdened with disputes relating to service conditions, with regard to appointments, with regard to dismissals, with regard to the service conditions, everything relating to administrative, with regard to service jurisprudence, the courts were clogged. Under these circumstances, they wanted an effective system or an alternative system. So therefore, they went into detail and the amendment was brought in, and these tribunals were created. So once these tribunals were created, earlier these matters were being dealt with by the high courts. Therefore, the question arose whether such a power which was given to high courts could be given to the tribunal members, who are basically people who are retired, whose chairmen were generally appointed, who were qualified to be appointed as high court judges, or who were already were serving as high court judges and superannuated thereafter. And very importantly, the members were not judicial members. In most of the cases, members were administrative members with no judicial backup. So under these circumstances, these issues arose. Number one, whether you have created a tribunal which was it a substitute for a high court, or does it act as a supplementary role? Does it play a very supplementary role? Now, what it did was, there was an act, Central Administrative Act. Under that act, section 28 specifically excluded the jurisdiction of high courts under Article 226 of the Constitution of India, and impliedly also excluded the jurisdiction of Supreme Court under Article 32 of the Constitution of India, and it held that the decision of the tribunals would be final. Now, first thing it did was to knock away the jurisdiction of the high courts under 226. And the only gateway for a appeal, or for by way of a judicial review, that was given to a person who has been aggrieved by an order of the tribunal, was to prefer a petition under Article 136 of the Constitution of India. See, 136 of the Constitution of India was already there, existing as a constitutional provision, wherein you can prefer a challenge against any order of any court directly to the Supreme Court. Generally, the question would always be asked as to why you have not taken the High Court route and then come in appeal before the Supreme Court. Therefore, you will have to convince the court as to why in a particular case you have come directly to Supreme Court under 136, bypassing the other statutory remedies available. One very good case to the point was I think there was a case in Morgan Stanley case, where from an order of the district forum, wherein the issue of public issue was stayed by a district forum, a 136 petition was filed directly against the order of the district forum to the Supreme Court. Supreme Court did entertain that petition in extraordinary circumstances. And then they say that in extraordinary circumstances, you can always prefer an 136 petition. That is slightly digressing the point. The point I am making is 136 was already in existence. So therefore, the Administrative Tribunal Act, the special enactment, did not give something new under the act for us by way of an appeal, because 136 is not a statutory appeal also. It's a constitutional remedy. It's a discretionary remedy where equities play a great role, because the Supreme Court has said in large number of cases that even if a judgment is wrong, the Supreme Court may refuse to exercise its jurisdiction, equitable jurisdiction, if it feels that complete justice has been done. Therefore, 136 by ensuring that 136 is there by way of appeal to Supreme Court by the statutory enactment, there is nothing new that the Administrative Tribunal had given. It had only clarified, not even clarified, it has re-articulated an existing position. Therefore, the same thing is with regard to Article 32 also. But somehow, impliedly, I am saying that Article 32 is also excluded for the simple reason that the provision clearly says, if you look at 323, let me read that 323 straight away. It clearly says 323A, Administrative Tribunals. And now if you come to 323, this one, Parliament may by law provide for the adjudication or trial by administrative tribunals of disputes and complaints with respect to recruitment and conditions of service of persons appointed to public services and posts in condition with the affairs of the Union. Now, if you come to 323A clause D, which is very important, it excludes the jurisdiction of all courts except the jurisdiction of the Supreme Court under Article 136, with respect to the disputes or complaints referred to in clause 1. Therefore, what it does is it completely knocks away the jurisdiction of all courts except 136. Therefore, the moment 126 is the only provision which has been retained, by necessary implication, every other provision goes away. Therefore, your right to judicial review, which has been held to be a fundamental right, a very strong part 3 right that is available to any citizen, gets knocked away. Since 226 itself is a part of a part 3 right, the question is not even a constitutional amendment can alter that position. Today, the position is that any constitutional amendment which violates either your part 3 rights or which violates the basic structure of the constitution would be held to be declared to be a nullity or void and declared unconstitutional. But then there is always a presumption of constitutionality. It's for a person who impugns the said amendment to challenge it and get a declaration. Otherwise, it will continue because the presumption is always in favor of constitutionality. So now, since there was a presumption in favor of the constitutionality of this amendment, Constitutional Amendment 323A and 323B, which excluded the jurisdiction of high courts and excluded the jurisdiction of the Supreme Court also under 32, except saving Article 136, a challenge was mounted saying it violates the basic structure of the Constitution. It also violates the power of judicial review of High Court, which is held to be a strong fundamental right, a part 3 right, and therefore it was sought to be struck down. Now, what Chandrakumar did was that it did not strike down 323A and 323B. What it did was it saved the provision by reading it down. So, by reading it down, it did two things. Number one, it acknowledged the fact that the constitutional, that high courts are more clogged, and therefore you needed administrative tribunals with judges at the helm, with retired high court judges or sitting judges, as the case may be, as the statutory enactment provided, to lead the bench with technical members supporting that particular area of expertise for which the tribunal has been created. So therefore, what they did was they found that this the power of parliament to enact such a law was upheld. Number one. And number two, however, it read down to me and it read down those exclusions of 323D, which I had read out, to mean that 226 would also be available. That once if you are aggrieved by an order of any of these tribunals, they held that tribunals are subject to the jurisdiction of the high courts under 226 as well as under 227. They are not on par with the high court, and they are not even a substituted to a high court. So under this, by virtue of this judgment, what they did was they maintained the hierarchy of the courts by establishing the supremacy of high courts over all other tribunals under its jurisdiction, by ensuring that Article 226 remedy, 227 remedy, which is available to you, to a litigant, is protected. By reading down that particular provision to hold that along with Article 136, your right under 226 is also protected. So in effect, today, if you look at the provision as such, Chandrakumar does two things. It upholds the supremacy of the high courts and the Supreme Court as far as judicial review of their judgments is concerned, number one. And number two, it also ensures that administrative tribunals also function. So ultimately, Chandrakumar lays down this very important principle regarding constitutional. The highlights of the judgments are like that. It holds that judicial review as a basic structure. The court held that the power of judicial review vested in the high courts under 226 and 227 and in the Supreme Court under 32 is a part of the basic structure of the Constitution. Therefore, any provision excluding this power is unconstitutional. So, to that extent, they held that the exclusion of 226, 227 and 32 is violative of the basic structure of the Constitution. To that extent, that cannot be accepted. Number two, what is the role of the tribunal? They say that tribunals are competent very importantly, it was the second point, that tribunals are competent to test the validity of only the subordinate jurisdiction legislation, but not the parent act itself. They cannot deal with the virus of a particular provision. They can't strike down a provision. For example, if the provision is very substantial in nature, then they can't strike it down as being violative of Part 3, but they can hold that to be that the rules that are made subordinate to it, they can strike down a rule on the ground that it is discriminatory or it is violative of Part 3 or for any other reason. So they don't have the power to strike down the parent enactment. They don't have the power to strike down a legislative enactment, but they have the right and the power and the competence to strike down on the rule making power. That is, if the rule can be faulted or impugned on the touchstone of any of Part 3 rights or on the touchstone of it being discriminatory, then it could be struck down. That is one thing. And the third point that Chandrakumar makes it, that high courts are not, definitely these tribunals are not substitutes, but they are supplementary in nature, that they cannot replace the high courts in exercise of the power of the judicial review. Very importantly, what Chandrakumar also does is, it overrules SP Sampath Kumar versus Union of India, which had earlier upheld the provisions of the exclusion of High Court's review power. So therefore, it also overrules Sampath Kumar's ratio, that the earlier provision 323A and B, as it originally stood, Parliament was competent to make such an enactment. It had the competence to exclude the power of the High Court under 226 and 227 to test the orders of the tribunals that are impugned before the High Court. To that extent, Sampath Kumar stood overruled, and it is the first thing, and the other thing which I forgot to tell you, that this is a 7-judge constitution bench judgment. As far as Chandrakumar is concerned. And then they rule also on issues of administrative structure, namely that the courts recommended that all tribunals should, as far as possibly, be under a single nodal ministry. That's on the administrative side. But the broad framework under which Chandrakumar worked, I told you. Now, the second case that comes to mind regarding that has been the case study for today is Roger Matthew versus South Indian Bank and others. This is also a case wherein which challenges the constitutionality of Part 14 of the Finance Act and the rules framed in consonance with Section 184 of the Finance Act. The challenge before in Roger Matthew was slightly different. Now you will have to look the way things have worked out as a pattern here. Now, in Roger Matthew, what the state or what the legislature tried to do was, now that the administrative tribunals have been created and they have been upheld, subject to, of course, judicial review of the High Courts and the Supreme Court. The next came the issue regarding the appointment procedure and the constitution of the tribunals as to who man the tribunals and who manage the tribunals. Because ultimately, if you consider independence of the judiciary, it's extremely important as to who mans the judiciary. If the right person is there, the people's faith would be there. Whereas the moment people get to know, or probably there is a feeling that these are all appointments which are made by the executive, then people's faith in the very system would crack. For the simple reason that most of the litigations is against the state, and a party cannot choose its own judge. Under these circumstances, the very cardinal principle on which any judicial system could work would only be on the unquestionable faith that the people will have in the judiciary. And that unquestionable faith could very easily be questioned if the major part of the litigant himself has to decide on the people who have to man these institutions. If the appointment procedure has to emanate from the executive, and the executive itself is a big litigant before the court, then in those circumstances, the edifice and the foundation itself will shake. So therefore, what it did was, what Roger Matthew, in this case, the question arose as to the appointment procedure, the qualifications, and the other aspects involving the administrative tribunals. Now, what it did was that under Part 14 of this Finance Act, the challenge was to the finance, certain Part 14 of the Finance Act of 2017. Now, what Part 14 of the Finance Act of 2017 was that some 25 different enactments were amended. That is, several amendments, several acts which are statutory in character, statutory enactments were amended, which empowered the union government to administer all the tribunals, specifically with regard to conditions of service, mode of appointment, security of tenure, and requisite qualifications of its members and presiding officers. Therefore, what it did was those tribunals by this Finance Act, the appointment procedure, the qualification, everything vested within the domain of the executive. So this would have actually, if this would have been allowed to function the way it was originally drafted, then it would have actually ensured that it's a death knell to the very tribunals itself, for the simple reason that these are all appointments made en masse by the government, with judiciary having no say in it. The moment judiciary gets excluded from the appointment procedure, then there is always the doubt as to the very integrity of the system itself. So when this was, some 25 enactments were modified, were amended to bring in that those appointments and the security and the tenure of these judges would be made by the union itself. That was challenged. The issues before the court was whether the Finance Act, insofar as it amends certain other enactments, was it a money bill under 110 and consequently is validly enacted. We will not go into the question of whether it's a money bill or not, for the simple reason that is not germane to the issue as to whether germane to the issue at hand that we have today, namely with regard to the issue as to independence of judiciary and appointments, because this has been referred. Now, this is also subject to a larger bench deciding whether it is a money bill or not, because this was introduced as a money bill. So, in case ultimately it was held to be a money bill, then everything would fall. This whole provisions would fall. But for the present, let us assume that it is constitutionally valid, and let us go on that premise. So, the first question, whether it is a money bill or not, which has been referred to a larger bench, does not actually interest us today. Now, the second question is Section 184 of the Finance Act, which came into force on 1/4/2017, read as follows. This prescribed for qualification appointment or regarding the chairperson, vice chairperson, and members of the tribunal, appellate tribunal, and other authorities. And that what it did was under 185, 184, the central government could frame. See, the act itself was silent. The act only gave power to the union to frame rules. The question was whether the power to frame rules, basically the question is, there should normally, appointment procedures are all normally the job of a parent act. There should be a parent act and it is a legislative exercise. But here what it said was, this legislative exercise was given to the executive, because these were all brought under the rule making power. So when appointments were brought under the rule making power, the rule making power being vested with the government, ultimately what you cannot do directly, you did it indirectly here by giving the government the power to make appointments. It only said that what the law said was, the legislature, the enactment said that the rule making power regarding appointment here is given to the government. So therefore, it was attacked on the ground that there is excessive legislation, or there is an abdiction of jurisdiction, it's abdiction of its power itself. When we talk about excessive delegation here, that is what was supposed to have been the qualification. Normally, if you look at any act, the qualification for appointment, for example, of a High Court judge or for a Supreme Court judge, is provided in the Constitution itself, or with reference to some other enactments and statutory enactments wherein some people are appointed. Those qualifications are prescribed under that act itself. But for the first time here, by virtue of this Finance Act, this was this qualification was prescribed not under the Act, but it was delegated to the government and they could make rules. Therefore, it was not a case of excessive delegation. It was also argued that it was a complete abdication of the responsibility of the legislature, and that what the legislature was supposed to have done, it indirectly gave it for the government to do it. So that was struck down because 184 gave that rule making power to the government. And now what was held ultimately is that in the Roger case was that the strict interpretation was required, and then ultimately, if you look at it, they said that the delegation is permissible. They said that delegation is permissible provided it is not excessive, and then they upheld the constitutional provision regarding delegation of power, that is the rule making power was upheld. But what they said was you can challenge the rules in case they violate the constitutionality, or in case they go against excessive, in case they go against the purpose for which these people have been appointed. For example, if the qualification prescribes no qualification, if the rules say that they are going to be appointed with qualifications which are not, which probably is unacceptable, then the rule making power can be challenged. So what Roger Moore case said was, by this was a judgment of by a majority of 4:1, with one judge dissenting, Justice Hemant Gupta dissenting in this. What it held was the constitutional validity of that provision regarding rule making power was held not to be excessive, but it struck down the entire rules under the 2000, under that particular act. The 2020 rules were framed. The 2020 rules, they found it to be completely excessive and struck down the rules itself. Now, what it did again here was it saved the legislative provision, but ensured that whenever there are appointments to be made, if they are not in consonance with judicial norms, then such appointments can be struck down by the court. Now, what were the appointments that were struck down by the court is, it held that the search under this rule making power, there was a search selection committee which was heavily influenced by the executive with minimal judicial presence. Again, it came down to the appointment wherein executive had a big say. So therefore, the rules, the 2020 rules were struck down. And then it also said that the rules were struck down because it is violation of judicial independence. This setup undermines the doctrine of separation of powers and poses a threat to the independence of the judiciary itself. So therefore, ultimately, they gave a conclusion that it's very important to hold that these three, there is separation of powers. Legislative in its own field can do what it can do. The executive has a role to play, and of course the judiciary has a role to play. But anything which tries to tilt the balance in favor of the other will ensure that this delicate balance is upset. And especially with regard to appointments to be made, wherever the rules confer such a power on appointments, where it tilts the appointment procedure in favor of the executive choosing its own people, it would be struck down. And that's what they did. The rules were struck down as being influenced heavily by the executive, number one, and then it poses a threat to the independence of the judiciary itself. Because the qualification prescribed for the judicial, for some of the members were found to be an encroachment on the judicial domain, and it undermining the independence of the judiciary. This is with regard to the second case. Now let us come to the third case, namely Madras Bar Association versus Union of India, namely 2020 SEC Online SC 962. Now if you look at this particular Madras Bar Association case, it's a decision of 3 judges with a majority of 2:1. It related to a constitutional challenge to section 12 and 13 of the Tribunal Reforms, Rationalization and Conditions of Service Ordinance 2021 and section 184 and 186 2 of the Finance Act as amended. it was argued that it violates the independence of the judiciary and doctrine of powers, right? And then what actually happened in this third case, Madras Bar Association case, was that, just give me a second. Yes, yes. Yes. This was also a case which talks about administrative control of the executive in matters relating to appointment of judges as well as conditions of service. Now, if you look at certain sections which were held to be violative, it was held, if you look at, I have given a small chart, I will circulate this. I don't know. If you look at this, the summary of the summary of provisions that were declared to be unconstitutional was violative of Article 14, number section 84, 184, 1, and the first proviso, which prescribed a minimum age limit of 50 years, was held to be violative of Article 14, and the second provision, which declared pay parity with government officers, it was held to be affecting the independence of the judiciary. Similarly, the 3-month appointment rule was overridden. It was struck down, and as well as section 184, 1, 2 and 2, wherein a tenure of 4 years was already prescribed, which has been invalidated earlier, that was also struck down. So the majority struck down certain provisions of several provisions of the Reforms Ordinance of 21. Now let us come to the most important case in hand, namely the Supreme Court Advocates on Record Association versus Union of India. This is a petition regarding the appointment procedure of High Court and Supreme Court judges. A very important landmark case of the Supreme Court. It's by a constitution bench of 5 judges. The petitioner is none other than the Supreme Court Advocate on Record Association. See, what it did was it challenged the constitutional validity of the 99th constitutional amendment. I earlier indicated to you the provisions of Article 124 as well as the provisions of Article 217, which the earlier 3 decisions were regarding appointments to the tribunals and the constitution of tribunals. This Chandrakumar's case was with reference to appointment of High Court and Supreme Court judges. Now, as far as appointment of High Court and Supreme Court judges are concerned, there was a constitutional amendment. Namely, the NJAC was brought in by virtue of the 99th constitutional amendment. What it did was, it altered the provisions of 124 and 217 drastically. That is, till now, till at that point of time, whatever procedure was there was completely changed, and a National Judicial Committee, Appointments Commission, was to be put in place of the collegium system that was in existence. Now, as far as the NJC is concerned, NJC, according to the constitutional amendment, consisted of 6 members, out of which 1 would be the Chief Justice and the 2 senior most judges, and 1 would be the Union Law Minister, 4th one, and 2 eminent people to be again picked up with a predominance, with a complete tilt in favor of the executive to pick up these 2 appointees, two people. These 2. So totally there are a committee of 6, and amongst this committee of 6, the National Judicial Commission will select High Court and Supreme Court judges, which would completely, the challenge to this was that it erodes the basic structure of the Constitution, for the simple reason that the appointment procedure as such is tilted in favor of the executive. Now, what it did was, the whole act was struck down. The NJC was completely struck down, as being violative of the basic structure of the Constitution, because ultimately they say that primacy in the appointment should vest with the judiciary. The moment there is an executive say in the appointment of judges, people's faith will be completely eroded. And that was the basis. If you look at 124 and 217, it talks about the judges being appointed in consultation with the in consultation. Now, what the Supreme Court has held in this case, consultation means concurrence of the judiciary, and it is not merely consultation in the sense that they said that unless the Supreme Court concurs, that is, it should emanate from the appointment should emanate from the judiciary, and the ultimate say would be the judiciary, with executive having absolutely no role to play. So Chandrakumar, to that extent, this case particularly, I mean, is a landmark case. Supreme Court advocates on record association, which clearly it says that the NJAC was set up for selection, appointment, and transfer of judges to the higher judiciary to replace the prevailing collegium system. Now, this was a judgment which was rendered by a judgment of 4:1, with Justice Chalameshwar dissenting. Justice Chalameshwar holds that, in fact, that is a welcome. Uh, this one, it confers, it concedes to that extent. Justice Chalameshwar's opinion concedes that power to the government in to nominate the people and then to nominate judges to the higher echelons, namely the High Court and the Supreme Court, on the ground that they need to have a say ultimately, because they are in the role of governance, and they are also accountable to the people. But then ultimately it was struck down on the ground that it breaches the basic structure of the Constitution, and then the judiciary's primacy is being violated. Then one more question that ultimately came, this was one interesting point which I would like for you to critically examine as examinees, is that if you look at 124A, there's an important provision. It talks about every judge of the Supreme Court shall be appointed. I am reading 124(2). Every judge of the Supreme Court shall be appointed by the President by warrant under his hand and seal, after consultation with such of the judges of the Supreme Court and of the High Courts in the states as the President may deem necessary for the purpose. Now, it not only talks about consultation with the Supreme Court judges, it also talks with consultation with the judges of the high courts as well. Now, if you examine this, you look at the collegium system today. The collegium system consists of 5 members, all are from Supreme Court only. All the 5 judges are from the Supreme Court. Probably there is one consultative judge. For example, in case they are picking up some one judge from Madras to be elevated to Supreme Court, then already a Supreme Court judge who is from the Madras High Court, or who has information of the Madras, who was been there in the part of the Madras High Court in the Supreme Court, would be consulted as a consultative judge, and then the appointments would be made. Now, this collegium system effectively answers the description to one part of 124A, namely as far as consultation with Supreme Court is concerned. But as far as consultation with judges of the High Court is concerned, there is absolutely a lacuna here, because the collegium system consists of Supreme Court judges. It does not have any High Court representation in the collegium system. To that extent, 124(2), to that extent, the collegium system does not answer, according to me, the description of 124(2). And this is explained in the third reference case, wherein the President sought the reference regarding the role of the judiciary in the appointment. And then, while answering this, at one of the paragraphs, while answering the reference with regard to 124(2), the Supreme Court says that we cannot have different collegiums for different high courts. There would be only one collegium. So if you have to have consultation with High Court judges from the collegium, then it would be practically impossible to have a collegium system, because there could be cases where they may pick up, there could be cases where some of the judges may not be. How many judges from how many courts will you pick up? So regarding, they say that it is practically impossible to involve judges of the High Court because of the vastness of the judges of the High Court. And the Constitution 124 also, 2 also does not give an indication whether it used to be, it can be the Chief Justice of the High Court. Now, if the Chief Justice of the High Court himself has to be superseded, obviously you can't ask the Chief Justice of the High Court to examine as to whether the other person who is junior to him is feasible for appointment to the Supreme Court. Because then he has to obviously say that the other person is better than him or more competent. So under these circumstances, to that extent, there should be a device under our constitutional scheme of things, wherein in the collegium system, the representation of high courts in the collegium system, if it finds a place, then it will answer completely to the description of 124(2). Presently, we don't have that. Presently, as I said, we don't have that sort of a collegium system. Collegium system consists of completely the Supreme Court judges, whereas 124(2) contemplates the composition of some High Court judges in the system as well. So to that extent, probably it may need a correction. It's for you to critically examine. Now, if you look at 217 with regard to appointments of High Court judges, appointment of High Court judges, there is one more layer of one more filter, in the sense that if you look at 217, the consultation is both with the Supreme Court and the High Court. So therefore, the collegium system in every word completely is in consonance with the description of 217. Article 217 says every judge of a High Court shall be appointed by the President by warrant under his hand and seal after consultation with the Chief Justice of India, the Governor of the state, and in case of appointment of a judge other than the Chief Justice of the High Court. So appointment of a High Court, for the appointment of High Court judge, you have the involvement of both the judges of the, by the involvement of both the Collegium of the High Court as well as the Collegium of the Supreme Court. There is absolutely no infraction here. The collegium system is in consonance with 217. But when it comes to 124(2), the composition, the collegium system probably may not be completely in consonance with the constitutional scheme of things that is contemplated under 124(2). So that is for you to think and examine this issue. And now the next case is Dheeraj Moore. And yes, the fifth case, yes, Dheeraj Moore, this is Dheeraj Moore is 2022 SCR 161. This refers to appointment of appointment to judges of subordinate judiciary under Article 233. See, what it did was 223. Let us examine 223. Just 10 more minutes and I'll be through with this. 223, appointment of district judges. Appointment of persons to be and the posting and promotion of district judges in any state shall be made by the governor of the state in consultation with the High Court exercising jurisdiction in relation. Here also it talks about consultation with the High Court. Now, if you look at 233(2), a person not already in the service of the union of the state shall only be eligible to be appointed a district judge if he has been for not less than 7 years an advocate or pleader and is recommended by the High Court for appointment. So what was challenged is the rules under the conditions that were prescribed under 223(2), which contemplated that in order to be appointed as a district judge, it should have at least 7 years as an advocate. He should have a practice of 7 years as an advocate. The question that arose was whether the period of in-house service of a judge in the lower judiciary could be considered. It consisted of 3 categories of people that came up. Number one is whether this 7-year period would also include the period that that a person who if he has been a judge in the High Court, if he has been judge in the subordinate judiciary, whether he should be a person who could still be counted as a person who was having put in that 7 years of service. The second is people who do not. This is then the second one is a hybrid category, wherein if you combine his role as a judge and is practicing both put together, he completes 7 years. And the third is that 7 years of service of judicial. The third category is a hybrid category of combining the experience serving as a judicial officer and as an advocate. So all these categories of people, they questioned the logic behind this, or they said that we should also come under the advocate's category. What the Supreme Court said was that these are all different seats, these are all different streams of appointment. That is, if you are that if that advocate who has 7 years of experience is a class by itself and the classification is valid. So a judge who has put in a district a subordinate judge who had put in 3.5 years of service as a judge and 3.5 years service of as a practicing lawyer, you cannot club both and then say that he has got 7 years. 7 years of practice as a advocate means a complete 7 years of practice without mingling it or confusing it with his tenure as a judge or otherwise, or as even as a hybrid, even if you look at it that way as a hybrid category. Under these circumstances, they said that 7 years means appointment is of the person should be exactly having a 7-year experience as a lawyer. And then what were the ultimately it was held was that conclusions were members of the judicial service can be appointed as district judges by promotion or limited competitive examination. The governor is the appointing authority for appointments, promotions, postings, and transfers. And under 233(2), advocates or pleaders with at least 7 years of continuous practice, not already in judicial service, can be appointed by direct recruitment. So these were the conclusions. And it also held that advocates must be in continuous practice for 7 years, that you can't have a disjointed practice of suspension of service and then coming back to service to be counted. It should be a continuous practice of 7 years. And then that was how it was upheld, and then 7 years practice rule was upheld. Now the last case, I'm running short of time, I'll conclude this. The last case is with regard to is namely that Kavita Kamboj versus High Court of Punjab and Haryana. And this is a 3-judge bench case. The citation is 2024 7 SCC 103. Right. The issue involved arises from the recommendations by the High Court of Punjab and Haryana for judicial promotion under the Haryana Superior Judicial Service Rules 2007. What were the issues before the court? Was the imposition of a dual cutoff of 50% in the written test and Viva OC, valid under the Haryana Super Judicial Service Rules, and did the High Court have the authority to issue administrative instructions supplementing the rules? Here for the appointment, since it has here the High Court framed the rules, High Court stated that clearly stated that 50% for the appointment of a district judge, 50% should be written, 50% you should have in the written examination, and 50% you should have in the Viva OC. This was not a rule which was there in existence, but this was brought in by the High Court itself. So that was challenged on the ground that whether the High Court would have can give administrative instructions, and can it supplement the rules itself? And was there a procedural fairness in applying these rules? And the judgment highlights are something like that, held that the opposite 3 sources of recruitment. And what it said is that although recruitment is for filling same post, but candidates taking different routes are placed differently and hence must be tested differently. And what they say was that in matters of appointment of judicial officers of the subordinate judiciary, opinion of High Court is not merely a formality, and governor is expected to engage in a constructive constitutional dialogue with High Court and making appointments to the position of district judges. And it upheld that rule which contemplated 50% YOC and 50% written examination rule. So ultimately, if you look at these 6 judgments, to conclude, these 6 judgments drive home a very important pivotal point, and that is that appointments to judges of not only the subordinate judiciary, not only the tribunal, but including all appointments wherever a adjudicatory process is involved, including very importantly appointment to high courts, supreme courts, and in all other such appointments, that the independent, that primacy should be with the judiciary, so that there is no dominance of the executive over this appointment procedure, for the simple reason that people's faith would only remain intact in case these appointments are made by with a strong hand, with the involvement of the judiciary itself. So this is what I had made out of this. You can go examine that particular issue regarding 124(2) as to whether it answers, whether the collegium system answers the description completely, because 217 it answers. That is probably for you to critically examine. And thanks a lot. And if there are any questions, I'm willing to take.
Thank you, sir, for a wonderful lecture. There's only one question that has been asked. I'll just mention the question. It says that, sir, can we apply doctrine of colorable legislation in
Right.
Roger Matthew case with respect to section 184 of the Act?
That is true. That was in fact argued also. See, colorable exercise of power is where there is a power and you exercise that power for an oblique motive. That is the purpose for which it was given. You exercise that power in the guise of that for achieving that particular object. But then the object is actually, if you look at it deeper, it is something else. There can be a challenge on that, of course.
I would now request our president to please say a few words about, sir.
Thank you, Suresh. It was a very heavy-duty session because of very, very important judgments were on board. And now we have only 10 days to go for the exams. Everybody must be very nervous. But one thing I would like to say is that we've known Suresh for some two decades, that he comes from a very humble town of Tirupati. So all these, and he has come here, he was an AOR before, and now he's a designated senior. So the point is, any of those aspirants who are from the tier 2 or the small town, there is enough scope for you in Supreme Court to succeed. I thank you again, Suresh, on behalf of, and now I'll call upon, I think, Aditya, you can.
Thank you, Vipin sir. Now, on behalf of the entire EC of SCAORA, I, Aditya Giri, Member Executive, extend our heartfelt gratitude to Suresh sir for delivering an enlightening and comprehensive lecture to our AOR aspirants in the critical aspect of the judicial system. Sir's deep insights drawn from years of distinguished legal practice have provided invaluable guidance to our aspiring AORs, and I have enriched their understanding of these fundamental constitutional principles that form the backbone of our democratic framework. We sincerely appreciate Sir for graciously taking time from his busy schedule to mentor our AOR aspirants and share his valuable expertise with them.
Thanks a lot. The pleasure was mine.
And his contribution will undoubtedly inspire and guide their journey towards becoming competent practitioners before the Supreme Court. Thank you, sir.
Thanks a lot. Pleasure was mine, and wishing all the students the lawyers who are taking the exam the very best.
Thank you.
Thank you, sir.
Thank you.